This recording discusses the Supplemental Jurisdiction Statute 28 U.S.C. 1367. What's unusual about this statute is that it was created after the Supreme Court had already started interpreting Article 3 to include supplemental jurisdiction. So unlike a lot of the other forms of jurisdiction we've talked about, diversity, alienage, and federal question jurisdiction, here the statute came after the Supreme Court had already been interpreting supplemental jurisdiction to exist. So unfortunately, Congress is not writing on an empty slate. And as a result of that, one could argue that 28 U.S.C. 1367 is not very well drafted. It's certainly complicated for students, and this video is hopefully going to give you a little guidance when you think about reading it. I think it's easiest to start with the organization of the statute itself. I realize there's no subtitle sections in 28 U.S.C. 1367, but it's very helpful to know a little bit about what you're looking for. First, under Part A, you'll read a grant of supplemental jurisdiction to the courts. So this is really where we get the authority for 1367. Now this is important. In order to get supplemental jurisdiction, you need to meet the grounds under Part A. Part B is actually a limitation on the grant you see in A. So, in other words, even if you meet the requirements under Part A, Part B will serve as a limit of those. And lastly, we have discretion in Part C, where the court can limit its own discretion of. So let's move on to the actual statutory language. If you look at Part A, the first provision, except as provided in subsections B or C, or as expressly provided otherwise by federal statute, refers to that limitation that we're going to learn about in B and in C. So the except language actually is not part of the grant of the subject matter jurisdiction, but really a reflection of a limitation that's going to follow. The second clause tells us the actual grant, and any civil action of which the district courts have original jurisdiction, the district courts shall have supplemental jurisdiction. So let's look back a second here. What we're saying is that the district courts already have some original jurisdiction in this case, some independent basis of federal jurisdiction, like diversity, alienage, or federal question jurisdiction, or a combination of those. When we find claims in an action that have original jurisdiction, this statute now tells us the district courts have supplemental jurisdiction over all claims that are related to those claims in the action within which we have original jurisdiction, that altogether they form part of the same case or controversy under Article 3 of the U.S. Constitution. This should seem familiar. What you're looking at is the Gibbs standard. This is the constitutionality aspect of 1367, and therefore the statute is just incorporating the Gibbs test. So the language here should mean you need to have an independent claim with federal subject matter jurisdiction, and your claims that lack original or independent jurisdiction must be part of the same common nucleus of operative fact with those claims. The last sentence refers to the decision in Finley. It says here the Congress is expressly rejecting the Supreme Court's interpretation in Finley, telling us that there is supplemental jurisdiction over claims that involve joinder or intervention of additional parties. All right, so A is the Gibbs test. That's how we know we've got supplemental jurisdiction. But is that the end of the story? The answer is no. After you meet A, and that's an important prerequisite, we have to get that grant, you need to check the limitation in 1367B, sometimes referred to as the B bar. The first part tells us that any civil action of which the district courts have original jurisdiction founded solely on Section 1332, the district court shall not then have supplemental jurisdiction. So you see by the shall not have supplemental jurisdiction under subsection A is the limit on what we've just granted in subsection A. We're taking away from you. There's several pieces to the B-bar. The first piece is in the first part of the sentence that's bolded here, where the civil action is founded solely on Section 1332. This means that it covers diversity and alienage cases, but not cases that are federal question or cases in which you have a hybrid, both federal question and diversity or alienage. Originally, supplemental jurisdiction's limitation was thought to exist primarily with just diversity actions, but this has been applied, especially because of the broad language here, to include alienage. Alright, so we meet the first part of the B-bar if our action solely has 1332 claims. Those are the only reasons we're in federal court. Is that the end of the story? No. This only applies when there's certain individuals asserting certain types of claims. Okay, so our original action has 1332 claims only, diversity and alienage. We now look to the next part. The first limit is over claims by plaintiffs. Claims by plaintiffs against persons made parties under 14, 19, 20, or 24 of the Federal Rules of Civil Procedure, and then down to the bottom line, when exercising such supplemental jurisdiction will be inconsistent with 1332. So let's break this down. We know originally this is only applicable when the claim is solely based on 1332, and now we know when it's by a claim by a plaintiff, the original plaintiff in the suit. Any claim by the original plaintiff? No, just those claims in which people are joined under 14, 19, or 24, which is really a lot of the ways people get joined in suits. Is there anything missing? Yes, class actions that a plaintiff could join a group of a defendant class, but that's typically not very likely. So in general, when the original plaintiff is trying to use supplemental jurisdiction against new parties that have joined the suit, under most ways in which they join, 14, 19, 20, or 24. Remember, 14 is impleaders, 19, necessary parties, 20, the permissive joinder, 24, intervention. Under any of those methods, then the plaintiff can't do that if it is inconsistent with the jurisdictional requirements of 1332, which largely we think is interpreted to be, does this new person destroy diversity? In other words, what you're seeing here is Congress saying the original plaintiff who picked this forum is not going to be able to get around the limitations of 1332 by asserting supplemental jurisdiction when such supplemental jurisdiction would create a destruction of diversity of citizenship, or adding aliens in ways we can't typically do that. We'll see these in our hypotheticals in a moment, but what you want to do for the purposes of this video is try and create a rule statement for yourself. 1367b, the first bar, applies when a case is based solely on 28 U.S.C. 1332. If I was to look at the reason we're in federal court, it's only for 1332 reasons. Secondly, we have an original plaintiff asserting a claim, and they're asserting it against a newly joined party. And the exercise of such jurisdiction would be inconsistent with 1332 or destroy diversity. So adding someone I couldn't otherwise add because they were not diverse, I can't just assert my diversity suit and then join them in later. Or bringing in an alien in a way I otherwise couldn't, and then just trying to use supplemental jurisdiction to get around it. There's one other bar here contained in B. We still have the same original provision founded solely in 1332, but now we have claims by different individuals. These are over claims by persons proposed to be joined as plaintiffs. So we're looking at new people joining themselves as plaintiffs or being joined as plaintiffs under Rule 19 or Rule 24. Rule 19 plaintiffs are our necessary party plaintiffs. Rule 24 are the intervention plaintiffs. We can't do that when it would be inconsistent with the jurisdictional requirements. There's an important note here, though. There is some very important joinder rules that are missing. If you look at other ways plaintiffs might join themselves, they could join voluntarily under Rule 20 as joined plaintiffs, or they could join in a class action as plaintiffs under Rule 23, and both of those rules are missing from the list of the bar in B. This is very important, and we'll return to it again when we look at the case of Exxon. Remember again, it's not all joinder, but only those joinders which would be inconsistent with 1332, in other words, destruction of diversity. So if we were to summarize this bar, our B bar also applies when our case is based solely in 1332, and now we have a new plaintiff joining under Rule 19 or 24, and that would be inconsistent with 1332 or would destroy diversity. After the B bar, there is a discretion section in C, and I've just listed out for you here, and you can pause and look at these. The discretion limitations of C. And what I note for you here at the bottom is that this list is largely similar to the one we see in Gibbs, but it's not exactly the same. So what you should do is make a note of the distinctions, and we'll talk about that more in class.